Hello, my name is Jay Chowan. I lead the group called Angel Mentorship Group. This video is done for the group which is on the Facebook under the name Angel Mentorship Group. So today's session is on the subject of self-represented litigant and the limited engagement retainer. So today is the 10th of July 2018, and I want to talk briefly about what it means for a person who is dealing with the court system and represents himself. It's called self-represented litigant. And there is a fair number of them, you'll be surprised. I think that the remarks from some of the judges that you'll see is that the number is increasing. And I can only speculate, but my view is that the lawyers are pricing themselves out of the market, and I think the other problem is that notwithstanding the prosperity of Canada, it is not easy for the middle class person to find representation in the courtroom for an experienced lawyer at an hourly rate of about $300-400 or plus an hour. And specialist lawyer may even charge more than that amount of money, $300-500 an hour. And very often, just like the medical problems, the legal problems occur very often without necessarily something you're inviting, if you like, the trouble to yourself, but it will happen. When it does happen, then you have to deal with it because you cannot not deal with the situation. Let me give you an example actually that happened, and I'm dealing with it, that the bank terminated the employment of one person, and there's enough evidence that the person did not do that wrong, but because of the insecurity in the mind of the bank, there is a termination. So the person lost a job, and the person cannot find a job any longer, and therefore they don't have the money, and other banks are very reluctant to hire somebody that has been terminated in their employment from the bank, the financial institution. So they don't have the money to pay the lawyer. At the same time, they need the support to either deal with the bank, bring an action, and then find a resolution of the problem. So that is a scenario which is extremely common, and very often the lawyer is put in a place to make a decision how to help such litigant. So there are many who choose to simply represent themselves in the courtroom, and that is frequent. Now, when you reach the small claims court, the forms are reasonably simple, and the procedure are simple enough so that you can handle it yourself. But if you are in the higher court, the procedures are very detailed, complex, the rules of procedure, that even if you have gone to law school, you have to have enough experience to deal with it. And then if you have litigation without any background in the law or even experience of a litigation, then you are trying to deal with a lot of layers of experience. Firstly, understanding the law, then the procedure, then the experience that tells you how to evaluate the argument, and then be able to sometimes go in the courtroom, which is another big challenge, that when you go in the courtroom is intimidating, and for some people not used to being in the courtroom, a terrifying experience. So we put all these things together, and there you have the profile of a self-represented litigant. So I think that is typically what happens when you are representing yourself, and then how does the lawyer deal with it actually, in terms of it's your decision. How far can you help, and should you do some kind of pro bono work or charge minimal fees? Or here is another option that has opened up since the law society is now permitted, what is called a limited engagement retainer. The rules have been changed, and the new rule says that a lawyer may act for a client on a limited engagement retainer, provided that he tells the client what it means. Now, my experience I want to narrate to you is that there is very deep-seated cultural understanding in the mind of the client that the lawyer takes the responsibility for what he does. So when you tell the client that you are acting for yourself, those words don't seem to make emotional meaning to the client, and therefore he still looks at you. So you end up trying to tell him not only how to deal with the procedure, how to understand the law, but also take the responsibility for not only doing, but also trying to teach him how to do it himself. So can it be done? I think I have done a number of them, and actually my experience is that you have to select the client and say that this client is going to be capable of doing it actually. And then you take a huge amount of precaution to try to repeatedly tell the client what it means to represent himself. So the first thing they would do is to have a proper retainer actually, which is written down and in which it is said to the client that he is self-represented and that your engagement is limited to only what he asked you to do, and you have to document every time that he is self-represented and you did the document, and then you would then tell him basically that what the document means, that he approves the document, and that it's going to be filed in his own name. So you have to explain the filing procedure to him, and then how to prepare an affidavit of service, etc. The document is something that you can do. But what happens when you have to go to a courtroom and he says, okay, well, can you come to the courtroom? Of course you can go if you are ready, and if you have, then your client has a choice that he can engage a lawyer. And we had recently a motion that was heard by a lawyer who was representing a client who was self-represented. And I saw what happened in the courtroom is the opposing counsel, very experienced litigation counsel, brought it up several times, said, okay, so-and-so lawyer is helping this client, as if there's something wrong in doing it. In my opinion, it's not wrong. And I think that the rule was changed to make it more possible for more people to limit their expenses in terms of the lawyer's cost when they're self-represented. So my feeling is that if done properly, it will open the door for many more people to get some help from the lawyer and do whatever they can on their own. And it is my estimate that in a typical file in litigation, where you have so much documentation and procedural rules to comply with, then it would save an average person, I would say 25-30% of the value of the lawyer's time. For example, in the filing, you create a third-party notice and you have to give all the pleadings. So you have to explain either to the client, and they assemble the documents, they get a process server or themselves serve the document, they take it to the courtroom, and that would normally be done by the lawyer's office, and it all takes time. The lawyer is watching and creating a bill for the extra time that is spent on issues that really can be done at the level of a paralegal or a secretary. So in summary, I think there is a door to be opened for the lawyers and the public to recognize that this ability to be self-represented is there. There's a lot of research you can do now on the website at canlii.ca, canlii.ca, on the case law and the statute, and the procedure rules are also available there. And if you have a self-limited engagement retainer, it can save a lot of time and cost to the litigant, but it is a very difficult exercise, as I see in my experience. So if you have a question of this kind, especially in the group, please feel free to address it in the Facebook and make your comment below in the Facebook on this video. Thank you.